Okay, people against Thornton. Lamar Eugene Thornton. 24B 702123. Your name, sir? I have a charge here that alleges that you failed to clear all warrants within 30 days of your jail release. That is the charge. If you plead guilty, or if you're found guilty, that would be, that's a technical violation and you could get 5 days in jail. Do you understand that? I can't hear.
Yes.
Did you sign this advice of rights form and read and understand the rights? You plead guilty at any time, you will be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
You do have the right to an attorney. I'll be happy to provide you with one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
No.
The charge, you failed to clear all your warrants within 30 days of the date of your jail release. How do you plead? Not guilty?
Yep.
Okay, I'll get probation in here, then we'll have a hearing. You cleared all your warrants?
Yeah, well, clear everything.
When did you clear the last one?
The last one they just scheduled it,
Call in Beth.
for Dearborn, and I just had to get fingerprinted.
What about the one out of Detroit from July of 21? Did you clear that warrant?
Detroit, I already got
Okay, so you want to have a hearing though?
it.
But you still want to have a hearing, right? Okay, so, all right. Okay, we'll get Ms. Wiles in here. She'll testify and we'll go from there, okay? Recalling Lamar Eugene Thornton, 24B 702123 FY. All right. Your name, sir, again? Ms. Wiles?
Elizabeth Probation.
All right, so defendant pled not guilty to the charge that he failed to clear all of his warrants within 30 days of his release from custody. I'm going to ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth. So help you God. Okay.
Yes, Your Honor. As far as going back, the defendant had several warrants out at the time of his sentencing. He was ordered to clear those warrants on August 18th, 2025. I did run Mr. Thornton's record at that time on August 18th, which is going to be the date of the show cause. Mr. Thornton did still have a bench warrant dated 11/4/22 out of 19th District Court. Looks like this was a false ID charge. He had another warrant dated January 3rd, 2024 out of 25th District Court. That was for a civil infraction.
Did he add one on July 6th of 21 out of the 36th? That's the only one I'm seeing on this clean printout, but it's dated September the 9th.
Yeah, and I did speak with Mr. Thornton. He was making attempts to clear those up. I am seeing one out of our court issued August 8, November 1 of 24 out of 23rd, November 1, 24 out of 23rd, again, November 1, 24 out of 23rd, and then, as I mentioned, January 3, 24 out of 25th, and November 4 out of 22.
Do you have this one, July 6th of 21? Driveway license not valid?
I am not seeing that one on my printout, Your Honor. I'm not even seeing that as issued even during his.
Well, let me hand you this lien printout here. Sir, do you have any questions of her?
Do
Do you have any questions of her? Do you want to testify or do you wish to remain silent?
like to speak.
Okay, so if you're going to speak, this is a hearing. I'm going to swear you into an oath. Is that what you want? Sir? So this is a hearing right now. I'm determining whether or not you had warrants outstanding 30 days following your release from custody. She just testified. You said you don't have any questions. If you wish to testify, I have to swear you to an oath. Do you want to testify or do you want to remain silent? If you remain silent, I won't hold that against you.
Just-
Do you want me to swear you to an oath? Sir. You can't just, you see that I administered an oath to her, right? You see me ask her to raise her, if you're gonna speak now, I've gotta ask you to raise your right hand and I'm gonna swear you to an oath. Is that what you want?
Wanted to, it's like when you swear me, do I have to go against her or like can I just say,
You can tell me,
like that's what I'm confused. I don't know if like I gotta go against her or not.
what do you mean go against her? She thinks you didn't clear all your warrants. You pled not guilty. She just testified you had a slew of outstanding warrants 30 days after your, listen. I don't know what you mean by go against her. I've either got to swear you to an oath, in which case you're giving up your right to remain silent, or you can just tell me, Judge, I do not wish to testify. And I'll give you an explanation if you find me guilty following your decision on whether or not I had outstanding warrants 30 days after release. Do you understand? Do you want to testify? Okay. All right. So based on that testimony, I find that you violated probation.
In Your Honor, I just want to say the warrant that you're providing, Mr. Thornton does have aliases. It does appear that this one warrant that you have from July 6th of 21 is under one of his aliases.
Right. All right. I'm going to find you guilty of failure to clear all warrants within 30 days of release from custody. Now, listen, how many do you think you took care of? I need to know how many. Did you take care of one or 42? How many warrants did you take care of?
5.
Okay. All right, good enough. I'm going to keep you on probation. Pay additional costs of $50. Clear all warrants by October 1st now. Do you understand that? Okay? So you just clear all your warrants, you pay $50 and we're done. At least with regard to this violation. You understand everything?
Yeah.
Okay, so can you pay the 50 now or do you need time? So you pay that 50 now. Remember, you got to clear all your warrants, including this one out of Detroit. Ms. Wiles, will you tell them about it, please? Show it to them on the lien. We can't give you a copy of the lien printout, but you can at least show it to him. And he can go over to Detroit and take that.
Absolutely, Judge.
Okay, take care of that. Good luck. Thanks. People against Earl Hudson, 25W838-585B.
Your Honor, Michael Crawford, representing Mr. Hudson. Mr. Hudson, please state your name for the record.
Is somebody here from Clean Energy? Clean Energy. Do we have anybody out there, Lisa, that you can?
No, not on Zoom.
Let me call in Mr. Urick. Is he on 249? Boy, they were awful generous on this one.
Yes.
Morning, Your Honor.
Can you come in, Mr. Urick, please?
Of course, Your Honor.
Thank you. Okay, tell me, I can't wait to hear. So he was charged with leave the scene of a property damage accident and improper plate. He drove into a fence. He pled to improper plate. So what's the good reason?
Well, there's no good reason for why it happened.
No.
The reason he left the scene,
Okay,
reason he left the scene is because his boss ordered him to leave the scene. It was on the premises of the job defenses for the employer. He went in and told his boss what had happened. He was asking, they like, great, get up there and work. So he drove off to work in a work car and came back. He left his car right there on the premises. The boss said he look out for it. I think they came and left it there, right? But he told it. Yeah, they told it. And towing it away. So he just following the boss's orders.
well, the boss just can't tell him to commit a crime. Whoever your boss is has got a rock loose. Your name?
Good morning, Your Honor. May it please the court, William Urick on behalf of the city of Woodhaven.
Do you know if Clean Energy is gonna make any kind of claim for restitution? We sent a letter to them. We advised them of the sentence date this morning at 8:30. You had on your stip form, pay restitution, something to the effect, pay restitution is determined, or defendant responsible for any damage to property for restitution, I think it's saying. Do you know if Clean Energy is going to make any kind of a claim?
We have not had a claim as of yet. I can double check with Lieutenant Toller right now.
Would you do that?
Absolutely.
Okay, thanks. All right, in the meantime, I think we can go ahead, because if there's no claim for restitution, I'm gonna go ahead and check and see if, but let's just go forth with it, and then I'll see what he says about restitution. What would you like to say on his behalf? Where does he work?
Stevens is an Amazon party line.
I'm sorry?
Stevens, it's an Amazon freight department.
He's a delivery driver, Your Honor. Again, he feels terrible about the situation, but at the time he felt between a rock and a hard place. He reported it to the authority on the scene that he knew about. He thought that they'll get this thing expedited. And again, his boss said, okay, good for you. Get on the road.
What?
He didn't want to lose his job. He thought he could come back and get this thing resolved. But he's learned his lesson. Things can't do that.
Mr. Hudson, what are you, 62?
Yes, sir.
But what I suggest to you, Your Honor, if he tells his boss, no, I'm not going on a job, he loses his job, he waits for the police.
Well, he can't, I don't care what his boss tells him.
I know.
He can't tell him to commit a crime and then have the defendant come in here and say, I'm leaving.
Yes, Your Honor, I agree with you, and he understands that. And I was putting it was the state of mind that Bedrock, the boss, is saying, get up there and get to
Tell
work.
Mr. Bedrock that the judge thinks he better reevaluate what he tells employees to do under certain situations. You understand what I'm telling you?
Yes, sir.
What's wrong with him? What do you want to tell me? Anything?
It's ready to get it sold.
Your Honor, you should know my client.
He still has warrants too.
Yeah, you know, he's got a few things he's got to take care of, but because of his matter, he's inability to lead the state. He hasn't been working since his last
Well,
school.
I would have let him leave the state.
Well, he didn't mention that, Your Honor, that his job requires him to go out of state at the time. He just heard the orders, followed it, told his boss to go out of state, so he hadn't gotten any assignments. So he doesn't have any money right now. He can't address anything. He's looking forward to get through this so he can start working again and pay his fines, to do his things.
Clean Energy has not articulated a claim.
Thank you very much.
Thank you very much.
This is gonna be the highest. I'm gonna find somebody who's convicted of improper plate. You should have known better. You needed to know better. You got warrants out for your arrest. You need to take care of those. I'm not gonna put you on probation on this, but you need to go over and take care of those warrants. I don't understand. You got a warrant out of Chelsea from 20, you got a warrant out of Taylor from this year, and another one out of 36th District Court that recently came to light on August 28th. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4.25 or 60 days. Can you restitution to be handled through civil litigation? It was probably covered by insurance, is my guess.
I can imagine.
All right, how much does he have to pay today?
As I mentioned, Your Honor, he hasn't been working.
It's only been 2 weeks, though.
Well, Your Honor, he has to start working, then he's gonna get a paycheck chapter.
All right, tell me how much you can pay per week.
Well, the way these numbers work out, I guess it's approximately $15 a week, because he's proposing to pay $15 a month starting the 17th.
What? $15 a month?
$50 a month, but you asked weekly, so I kind of did the math on the fly.
Wait a minute, how much does he make in his employment?
He makes $15 an hour, Your Honor. He's a married man, he's responsible for the household, he makes $15 an hour. It's not a lot of money, Your Honor.
How many hours do you work?
Well, 20,
A week?
25, yeah. Every, there's about a week.
Why don't you get a new job?
Well, I gotta find one.
Well, go find one. $30 bi-weekly. I'll give you a little bit of leeway time. I'll start you beginning on October 8th. If you don't have the money at any time, you call the court, will go on Zoom, or you can walk in here on or before any due date. You don't need to be afraid. I'll be glad to let you do what you need to do. I don't want to bankrupt you. I don't want you to go without food or heat or anything else. Use your head, please. Okay? All right. And I'm serious. I don't care how many times we have to do that. If you don't have the money, you talk to me. Don't ignore me like you're ignoring these other judges in courts. You understand?
Yes, sir.
All right. Good luck. Destiny Danye Henry, 25W837-840. I want to know if there's a Jason Haney out there anywhere.
Morning,
Not on Zoom.
Representative, Miss Henry, Matt Stitching.
Destiny and
He didn't show up. She just had one taken under HIDA. I'm not taking this under HIDA too. This is the same type of thing. So let's call in the prosecutor 249 and we'll go from there. There was a no contact provision in effect. I don't care if he called her up, said, come see me. I don't care what the situation was. You have no business having any contact with any victim here. None. You're violating court orders. I don't have anything on the restitution issue, so I'm going to have to ask Mr. Urick about that too. But here's the deal. I'm going to tell the prosecutor I'm not going to take this under HIDA. Counsel, your appearance again. I'm sorry.
Again, Your Honor, just proclaim right now on behalf of the city, Woodhaven, Your Honor.
She had another case taken under HIDA for domestic violence. She pled guilty a month before this event. She was ordered not to have any contact. He went over there and picked his car. In violation of the no contact order. I'm just not going to take this under HIDA. I will allow you to withdraw your plea if you'd like. I need somebody to check on restitution on this one. It sounded like when I read the report, there would have been quite a bit of damage. And I recognize again that they made arrangements, the victim and the defendant, to speak, but that does not excuse your obligation to courts. You can't do these things. So that's how I feel about it. You guys figure it out. If you want, I will reschedule it and let everybody grab their bearings, and I'll reschedule it for or you can go talk and resolve it today, whatever you'd like.
Your Honor, my client would like to withdraw a plea and would like to discuss with the counsel. I'm sure we get it resolved.
All right, I'll just make a note. Told defendant will not take per HIDA. Defense allowed to and did withdraw a plea. So we're back to square one. Now, this case has been going on quite a while. So if it's not resolved today, you're probably going to have to set it for a final plea trial and a trial.
Your Honor.
Plea allowed withdrawn. Okay, ma'am? Thank you. Alicia Marie Craig, 25W838-685A and B. Is Alicia Craig here? Did you talk to your lawyer?
yes,
Who's your lawyer?
I gotta tell you that,
Mr. Carmen.
Mr. Carmen,
Can you get him in if you will? Come on up to the podium, ma'am.
I was actually out there looking for him. I forgot to tell him something, but I guess I'll read.
Totally there.
Yep.
There it is. Play.
Yes. Thank you. He's not working.
There isn't original charge. I'm gonna take this back to you. I need some clarification on this one. Mr. Carmen, your appearance, this is, let me call the case again. Alicia Marie Craig, 25W838-685A and B, your appearance.
Michael A. Carmen, P7324, and a half Defendant.
Ma'am, your name?
Alicia Craig.
All right, so today is the date scheduled for arraignment on an operating with the presence of drugs and drive while suspended, revoked, denied. For purposes of arraignment, how does she wish to proceed?
Your Honor, she'll stand here, wait the formal reading.
Okay, I'm entering a not guilty plea, ma'am. I'm gonna give you a $1,000 personal bond. She does not have any prior, oh yes, she does have a prior in 2020, right?
I believe that was out of state, yes.
Yes, okay.
I mean, it still counts. I just want you to know that,
No, it does.
okay? All right. $1,000 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. No contact with prosecution witnesses. Attend NA at least twice a week in person. We're going to give you a form. You have to go in person every time you go. You have to have the form signed every time you come to court. You have to bring the form with you. So again, no alcohol, marijuana, or illegal drugs. NA twice a week. No contact with prosecution witnesses. We're going to give you a new date. It's going to be what, October 1 again, Lisa?
9:30.
At 9:30, okay?
Your Honor, my client is prescribed marijuana for chronic pain and anxiety. She uses it 3 times a day. She's been prescribed since 2017. Can she use that while on bond?
Is that a medical marijuana card?
It is, but I believe hers is expired.
Well, I can't. It's,
The only reason I did not renew it is because it became
hang on.
legal.
I can't give you permission to use marijuana when you don't have a medical marijuana card. I can't do that. I mean, that's like me, the judge saying it's all right to do. No, I just can't. I'm sorry.
If she gets it renewed and valid, can she?
Well, if she gets it renewed and you guys bring it up, I will certainly give her, ma'am, hang on.
I don't think.
Hang on. I don't think we should talk about this much now. You've got it looks like marijuana was the culprit here, right? Ma'am, let me just talk to your lawyer. I don't want you to say anything. Well, I don't want you to say anything against your, right, against your interest here. It looks like marijuana was the primary culprit in this, right?
That's what's.
So now you're asking me to say it's okay for her to use marijuana when she got charged with operating with the presence of drugs. I'm not doing it. Now, I don't overrule voters or the legislature, okay? She gets a valid medical marijuana card, you guys can renew your request, but this scares me because you can't go out and drive around with it in your system like that. So that's what I'm doing. NA twice a week, no alcohol, marijuana, or illegal drugs. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You're going to have to fill out a petition for a court-appointed lawyer going forward here. Okay, ma'am? Do you understand that?
No, but I'll figure it out.
Well, this lawyers are appointed for arraignment. If the rest of the representation is based on indigency, so you have to disclose your income and fill out that form. I'll look at it. I'll be glad to appoint you one if you qualify, okay? Thank you.
I'm sorry, Your Honor, what was the next court date?
October 1 at, would you say 9:30, Lisa?
Yes, 9:30.
Yeah. Okay. Thanks. Aaron Stephen Francia, 25W8392766A and B.
Ready, Your Honor. So,
All right, your appearance,
Good morning, Your Honor. May I please report Resolution Aquabog P 72819 on behalf of defendant Karen.
Sir, you have to start your video, please. There, and I'm gonna ask you to take your hat off there. Tell me your name.
Aaron Stephen Franchuk.
So he's gonna plead responsible to defective equipment,
That is correct.
and they're going to dismiss the no trailer plate, right?
Correct, Your Honor.
Is that what you want to do, Mr. Franchiuk?
Yes.
To the charge of defective equipment, responsible or not responsible?
Yes.
Responsible?
Yes.
I'll accept your plea, dismiss the original charge. 125 is your total. And when I say dismiss the original charge, dismiss the no trailer plate, you pay 125. Can you pay that online now?
Yes, I can.
We'll take care of it today, Your Honor.
Thank you very much. Have a good day, counsel.
Thank
Take
you,
care.
Rob.
Nice to have you here.
Thank you.
Thank you.
Good to see you.
Jose Hernandez. I'm not clear on this one. I don't know whose this is. Mr. Urick, I'm gonna need him, and I don't know who his lawyer is. Who's your lawyer?
The last guy that was over before. Mr. Harmon.
Come on up, have a seat right at the table here. Justin Robert Rodriguez, 25B14809. Justin Rodriguez, is he on Zoom?
No, I don't see a Rodriguez on the docket.
I just got this file here. It says time to pay.
Oh, that's a time to pay walk-in.
Where's he at?
He had cases with Judge Hessen also. So you had to see the arraignment attorney.
Mr. Urick, I need you to clarify these. I don't think it's written up right. You got, it looks like you're dismissed. Maybe you switch them around, but if the intent is to plead the no ops, you gotta just fill out another form there. I don't have a problem, but, okay. Noah Ryan Moore, 25 W8391308. And B, is your lawyer here? Come on in, Mr. Crawford. Your name's, come on up here and state your name, sir.
Your Honor, Mike Crawford. Start station name for that.
No, Rocky.
Boy, I can't keep adjourning this. We've had at least 4 adjournments here. How many times are we gonna adjourn it?
Well, this would be the final one, Your Honor. He's got an appointment with the Secretary of State
To do what?
to try to remediate issues. So you
All he's got is an expired license.
understand, but the prosecutor throughout the conversation become clear that he can take care of the issue.
Well, how come he hasn't taken care of it before? I arraigned him July 23. This is September. Why haven't you done this before?
I've been really busy with work.
Okay, so you got, I don't want to hear it. We're gonna have to set it for trial. You want a jury trial or a bench trial? I'll give you a final pretrial, but I'm not gonna keep rescheduling this. So do you want a final pretrial or a jury trial or a bench trial?
Bench trial. I'm sure we'll have it resolved someday.
Well, he should have taken care of this a long time ago. I need the prosecutor on this one. Sir, you have the constitutional right to a trial by a jury. Your lawyer tells me you wish to waive your right to a trial by a jury. If you waive your right to a trial by a jury, I will be the one who will solely decide your guilt or innocence. Do you understand that?
Yes, sir.
Do you wish to give up your right to a trial by jury? Anybody force you to do that? Somebody forced you to do that? You understand a jury trial consists of 6 people that would be impaneled. All 6 would have to agree beyond a reasonable doubt that you're guilty of the offense charged.
Yes, sir.
And you still wish to waive your right to a jury trial. I can't hear you.
Yes, sir.
October 1 will be the final pretrial, Lisa, at
9:45.
9:45. The trial date will be
October 15th at 11.
October 15th at 11 a.m. So I just want you to know on this one, Mr. Urick, your name,
William Urick, the city Woodhaven.
he's already had 3 or 4 adjournments. So I'm going to set a final pretrial on October 1. And do you have any objection to a bench trial, Mr. Urick?
None.
They've already waived it, so we're setting the bench for October 15th. That's the only reason. Well, Jen,
200 rounds.
thank you.
Thank you, Ron.
Yes, you don't understand what told her. That's correct.
What didn't you understand?
Did you want 2 NA and 2
2 AA or NA,
NA or 2 AA?
or a combination?
Okay, just 2 total weekly? And then, as far as the marijuana, I wasn't understanding, cause I'm.
Come on back up.
Come back up here, man.
Alicia Marie Craig, 25W386858B. Slow down. You gotta slow down.
Can I get?
No, just slow down. Tell me your name.
Holy shit, crap.
Like Carmen, B73824 on behalf of.
You can go to AA twice a week. You can go to NA twice a week. If it's more of a drug problem, you should probably go to NA. And you can go to any combination. I cannot permit you, I will not permit somebody who comes in here on a drug driving involving marijuana to use marijuana when they don't have a medical marijuana card.
That's not what I'm asking, Your Honor.
What do you ask?
I'm asking, I just would like to speak instead of being yelled at.
Am I yelling at
Not
you?
you, him, when he's got upset, he's supposed to be working for me, I'm just trying to understand, you even talk to me.
Ma'am,
I'm asking if I come back.
ma'am, let's back it down. Let's back it down.
Yes. I'm asking when I come back on my court hearing, when I drop, there will still be marijuana in my system.
You don't need to worry about that. You're making admissions
That's-
against, hang on. You're making admissions against your interests, which is what I just told you you shouldn't do, and I think your lawyer did, because all I know is they think in the citation that there was marijuana. Now, it was marijuana's involved. So why in the world would you come up here and start telling me you're going to test positive for marijuana? Don't do it. You're not a lawyer. I know we get at least 7 people in here every day that think they can be lawyers. They can't be. I've seen maybe one do it slightly average in my 31 years on the bench and 41 years as a lawyer. So you just gotta relax. Nobody's asking you to test anything right now. I never said you're gonna test.
No. Because I'm scared because of yesterday.
What happened yesterday?
I spoke 3 times a day that we had said, and I don't want to get in trouble. When I come back to court, I'm scared to get in trouble. You
Slow down.
guys,
Slow down. What happened yesterday? Do you know?
I spoke marijuana 3 times a day and
Ma'am.
that's all. And I just want to clear.
Ma'am, why are you coming up here and admitting this to me? You got a lawyer. Stop. Stop. Ma'am, just let everybody do their job here. Nobody's going to be unfair with you. Why would you come in here and tell me this on the record when you got a marijuana drug charge? A drug driving charge? You don't have any business telling me this. Don't tell me this stuff. I don't want to know about it. You tell your lawyer. And then he can tell me what he wants to say and what he knows is going to hurt you, not say, etc.
And Your Honor, that's why I didn't speak previously, that my client just used medical marijuana.
She can't use medical marijuana because she,
Until today. It's been prescribed her since 2017 for back pain. And
that's great. She's going to have to get a medical marijuana card.
I understand, that's what I.
And then I'm still going to have some issues, but we'll see. I mean, I'm concerned about this. The more I hear, the more concerned I get. And you had 1 4 or 5 years ago, you're going to have a revoked license, ma'am. If you get convicted of impaired or OWI, you're going to have a revoked license.
Yes, sir.
You're not going to be able to drive from here to that council table right there. You're not going to be able to do anything except have somebody in the driver's seat and you push the car. Stop telling me these things. Talk to your lawyer. I did not say one thing about testing. You put me in a position where I probably have to order testing now.
Let me just clarify. Sorry.
Your lawyer knows. He's been in here.
Sorry, if I may, I just noticed on my schedule, I'm not here October 1st.
Well, whoever is going to be the lawyer here is going to handle the case.
Just want to clarify that.
Okay?
Make sure that the lawyer gets his covered.
All right. Thank you.
Thank you, Your Honor.
Thank you.
Mr. Crawford. You guys got to read between the lines. You think there's a big difference to me between I'm not doing a no contest plea on an MDOP and I'm not doing a 771 instead of a HIDA. She violated a no contact order. I'm not doing this. In regard to custody, no, I'm just not doing this. It's just not something I'm gonna do. I mean, this was the same type of offense as far, no, I know one's assaulted, one's destruction of property. But she was on probation, just put on probation, and it is alleged that kicked the car and damaged the car. Now, I don't know what to tell everybody here, but I'm not gonna take it. I'm not taking a 771. I'm not taking HIDA. I'm not taking anything else on this. I'm sorry.
Well, let's go back to the drawing board.
Well, you guys go back to the drawing board, but understand that's, so I'm gonna call, Philip Davon Gibson Perry, 25W839417, A and B. Mr. Urick, I know we're going through this a lot today. Your name?
William Derrick, I mean, you happen to say what it.
I don't know if you accidentally sent in this Gibson Perry file. But it was all of a sudden on my desk and it came in with the last ones, Mr. Hernandez. And I don't,
Was not supposed to be here, Judge.
pardon?
I believe that's a Akron, Ohio resident who has not appeared.
Okay, that's what I wanted to make sure of. He did not appear, right?
That's correct.
So I'm just gonna go ahead and issue a show cause on the A file, suspend and default judgments on the B and C for failure to appear today. Thanks a lot.
No, thank you, Judge.
Do we have another one?
All 6 Davis files.
Okay,
Do you want me to bring those in now? He's the jailer. We had to get the police report squared away for his no contest, please.
do we have a lawyer?
Mr. Crawford will be the lawyer. This is a 3 for 3. There's 3 in front of Judge Coleman Hessen that are being dismissed, and then Your Honor is hopefully taking.
What kind of case, what kind of,
These are all retail property.
why are we doing no contest?
This guy is.
Well, you will have to, let me see the file. I doubt. Yeah. Retail fraud and theft offenses should never have no contest, please, unless there's a complete lack of memory. It's different on a assault case. It's different on. I have no idea. Destiny Danye Henry, 25W837840.
Afternoon, Your Honor, Mike Hill Crawford, representing Ms. Hinton, who's approaching.
I have not done this in years, but I cannot take this bill for this plea. I'm not gonna do it. Your name? I wanna make sure I got this straight.
Yes, you are.
Domestic violence charge, item, in front of Judge Hess.
Right.
Sentence, no contact provision. Goes and ends up having a reasonable, has some kind of a discussion with the victim. Kicks the car door, damages the car. Sounded like a significant amount of damage. I tell you guys I won't take hiding. Then you come back with 771.1. And now you're gonna have me take a plea to a municipal civil infraction. I mean, I'm not blaming you. I'm just telling you, I'm not taking it. I will not take this unless there's a valid reason for it. What's the valid reason? Is she running for Congress? I mean, I'm dead serious about this. What?
The whole nature.
She already pled to destruction of property. And then we go back to 771. And I can't even. I'm not even sure I'm able to. Yeah. What is going on?
Well, the prosecutor and his officer with a great pains and stakes to try to find the best appropriate one that they can.
Get the prosecutor and the lieutenant in here, please. My Lord. And the lieutenant. I just feel like sometimes, and I don't want to be the bearer of bad news on this one because I see it all the time. Where's the accountability of anything anymore? She violates a judge's no contact there. Guys, I gotta see you both in here, Lieutenant, and you guys, can I have your names, please?
Good afternoon, Your Honor. May it please the court, I may have to see Woodhaven.
Lieutenant Toller, David.
Guys. What do you think? Does anybody have any clue what I'm thinking? I want to tell you how I'm feeling. I take this young lady's plea. I read the report. I'm aware of the fact that she pleads to HIDA under 7694A. I'm sorry. Yeah, it takes a HIDA plea, I should say, on the domestic. Goes in front of judges. Is ordered not to have contact. Has contact with the victim. Sounds like it was a mutual thing. He wasn't innocent in all this, but as you know, I don't order victims not to have contact. I have no authority to do that. They get into a dispute. She kicks his car. I take a plea under HIDA, unbeknownst to me at the time, that she just pled on a domestic in front of Judge Hessen for HIDA. I send it back saying I'm not taking HIDA. You send it back saying take it under 771. And now you guys are sending me a municipal civil infraction?
Your Honor, if I could speak to that.
I want to hear it. I got to tell you, I try not to get involved in what you guys do. I bite my tongue up here all the time on both sides. This is ridiculous. So yes, I'd love to hear it.
Your Honor, to begin with, I believe the court was concerned about accountability. The people believe that given the fact that she is on an active probation with Judge Coleman, so there may or may not be some form of a violation of probation, not required to be triggered by a conviction, but simply the contact issue. The second feature that developed.
There is no conviction now if I take this plea. There's a conviction for nothing.
And there wouldn't need be at a violation of probation hearing. The contact is a violation of probation in and of itself. As in real time this matter was developing, we tried to reach the victim again. So he has been hailed by the probation department and by us and has been non-responsive. These young people have an ongoing custody issue before the front of the court in the Third Circuit. This young lady, as I understand it, is well employed at a call center, I believe. And obviously the court has all the discretion to disagree with the people, but I believe that given the complexion of things as they develop, specifically with respect to the, what's the word I want? Inactivity or incuriosity of the victim in trying to shepherd this case, I believe that this was a reasonable outcome. Thank you, Judge.
And Your Honor, we obviously respect your concern for the violation of the first order, but as counsel stated, my thought process was similar. If Judge Hessen has an issue with it, she can be held accountable for that violation before that court, not be penalized here in a separate subsequent case.
Guys. I must be missing some. So because I say I can't take this under HIDA, and I'm not going to because it was a domestic dispute, and she just pled guilty to and been sentenced on a domestic dispute a month earlier. And then you guys sent in the 771, and now you want to tell me Judge Hessen can revoke. Judge Hessen can take steps on her case. Number one, I don't care what people do. I made that abundantly clear. I don't think we treat people better. Call center, great. Lawyers, doctors, dentists, priests. I don't think we treat anybody differently based on who they are, what they do, who they know, or how much money they make. And I've said that for 30 years and I believe it. So let's throw out the employment thing. Let's not talk about her employment. Let's talk about something called justice. Let's talk about something called justice. Let's talk about something that has to do with holding people accountable. Giving them breaks when they're deserved. And everybody deserves second chances. But not in this scenario. I find this to be, first of all, let's just call it the way it is. Judges are not really legally authorized to tell people that they're not going to do something that the prosecutors are off. This used to drive me crazy when I was a young judge. Still bothers me a lot. Because there's no justice being served here. I just want you to know that's my feeling. And when I'm done doing this, I'm going to take this plea. I'm going to take your plea, man. You're going to walk out of here with something that is 99.8% better than what they offered you 2-3 weeks ago when you pled to malicious destruction of property. And the only one that called it was me. Because it isn't right. It's not right. I don't care what anybody. You could line up 150 prosecutors, they could all agree with him. 8,000 defense lawyers, line them up, they could all agree with me. I'm still going to be the one to say this is wrong. It's just wrong. It's just wrong. The idea that Judge Hessen can or cannot do something or should or shouldn't do something is part of this agreement I find to be hogwash. But the thing about me is I'm not going to overstep my bounds. At least I do my level best every day I come in here to not overstep my bounds. I think this is ridiculous. I'm just telling you. You have a deep problem going on right now. And that deep problem consists of, for whatever reason, a lack of respect for the judicial system. And it's cases like this that make me say, gosh, I can understand somebody thinking this is nonsense. I just can't. Now you're going to walk out of here in great shape, and the only thing is you had to listen to an old guy talk to you and call your case 4 times today. I didn't. I just want to go on record and say I don't agree with this. I don't think it's right. And if somebody gets hurt in this, the blood's going to be on somebody else's hands. That being said, you're recommending a fine of $150 under 94-2. I think I have absolutely pretty much no authority, although I just don't believe in the logical nature of your argument, Mr. Urick, but nonetheless, I'm going to take that plea, municipal civil infraction 94-2. What is it called again?
It's misuse of streets and sidewalks, Judge.
Misuse of streets and sidewalks. Now forgive me, I gotta laugh. Did she spit on the sidewalk? I don't want to talk about it. I mean, I feel like I gotta go take a shower after just even presiding over this case and take a plea to the charge of misuse of streets and sidewalks. How do you plead? Responsible? So she kicked the hell out of the guy's car. He's not here. He didn't show up for restitution. Original charge is dismissed. Motion to the prosecutor. Agreement of the defense. Ma'am, go down the hall and pay your $150. And consider yourself, you should probably go buy a lottery ticket or 49 of them right now. Have a nice day.
Yeah, you got to the end of today?
4 o'clock.
Thank you, Your Honor.
Thank you. Anthony Stefani. Are you Mr. Stefani?
He's not the number on.
Anthony Joseph Stefani, 25W701244.
You did.
You have to unmute, Mr. Stefani.
Hello,
Your name, sir?
Anthony Stefani.
You scheduled a revocation hearing. I'm gonna need Beth Wiles. What is he going to do?
Like a brother, Mr. Bonnie, still got to face my father, he guilty to each, with estimate.
Sir, if you plead guilty here, and by the way, Amy, on that last case, make sure she cancels all the bond conditions. I have a stamp and I forgot to write it down in all the excitement. If you plead guilty, Mr. Stefani here, I want you to understand that you could have, this would be 3 prior technical violations. You could be incarcerated for 15 days. Do you understand that?
Yes.
You are presumed innocent. They have to prove you guilty by a preponderance. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and the testifier remains silent. If you remain silent, that silence will not be held against you. Do you understand that?
Yes.
To the charge, you failed to attend your scheduled probation visit on April 21 of 25. How do you plead?
Guilty.
To the charge, you failed to complete the domestic violence program with 8-week follow-up. How do you plead?
Guilty.
To the charge that you failed to pay fines and costs as ordered. How do you plead?
Guilty.
You failed to attend the domestic violence program and failed to pay your fines and costs. Sir,
Guilty.
did you fail to attend the domestic violence
Guilty.
program and fail to pay your fines and costs?
Yes.
Did you fail to attend your scheduled probation visit on April 21 of 25?
Yes.
Anybody force you to plead guilty?
No.
What's he in custody on?
Doesn't matter. Picked up at his friend's house on the porch last Friday.
You're not going to do this, are you, Mr. Stefani? You want me to just revoke your probation? Is that what you want me to do?
No, sir. I was been in the hospital a bunch of times since I got out of jail. I did 60 days on this matter already. Since I've been out, I've been trying to get my money together and, trying to
Oh,
stay
you didn't
out
do
of the hospital.
62 days on this case. You had 32 days, credit 32 at the time of the sentence, and now Judge Heston set a bond on you because you just don't show up.
I already
Hang on.
Yes, sir.
And she set a bond on you on September the 15th, which was 2 days ago. It looks like the 15th, right? Yeah, that was only 2 days ago, so I don't know what you're talking about.
Well, Your Honor, he missed the last show cause here because he was hospitalized. That's what he was.
All right, let's do this. I'm going to set a sentence date. Is this the only thing he's in custody on?
Yes, Your Honor.
I'm going to read. Is that right, sir?
Yes, sir.
Hold on, sir.
I injured.
Sir, please, hold on.
All right. Yes, sir.
I'm going to set a sentencing date. I'm going to release you on a personal bond. You're going to show up here on when Mr. Crawford's here again. We're going from 7,500, 10% to a personal bond. So I'm reducing the bond. Amy, make sure Lisa sends that in, and you can give me the date when Mr. Crawford's here next. When are you here? October 1 at 8:30. You have to show up here, sir. You still live on Oakcrest, right?
Yes.
We'll send the notice there. Beth, I'm sorry to have called you.
Pending matters in Judge Heston's courtroom today. I could be wrong if the docket can be checked. I thought he had a,
Very well.
okay, that, I didn't know it was already done with Judge Heston.
He's good.
Okay.
Thank you, Your Honor.
Thank you very much. Do you have any more for me?
Theoretically, there's Shaw, but he's not out there.
We're gonna have to reschedule that again. We can, give me that file, please.
I think I've got it.
Just give me the file, Paul.
Mr. Carter's going to go get shot.
I can't do it. I can't do those things. I'll do them tomorrow. Give me the case, the docket. I just need the docket. And I'll call the case off the docket. People against Jeremy Dwayne Shaw. What happened to Kenyatta Davis? Jeremy Dwayne Shaw, 24W834-431. Jeremy Shaw's not out there.
Michael Crawford representing Mr. Shaw. I have not spoken with.
What happened to the Davis case?
I haven't spoken with him either. I don't know if he showed up, but I have filed.
David checked in with me.
Wait a minute. Who was the 3 retail fraud?
Davis,
She's not here?
as far as I know, I haven't spoken with him.
David checked in with me.
So Shaw was released, though, it appears. Defendant released. Okay. Jeremy Dwayne.
Judge, I checked and Shaw is still in custody as far as I can tell at Wayne County.
Okay, this was Monroe County defendant was released. So I'll
He's now
just
in
make
custody in Wayne County, I think.
I'll make a note, reschedule. Defendant's still in custody. We're gonna have to try to get him out of there if this is, I hope this is not. I don't know. At any rate, that's it. And this is the one you also have the motion.
There's a motion, says.
I know, that's what I'm telling you. I don't want to sit here and lecture you. You send me these retail fraud, you say lack of memory, so possibility of civil litigation, you're filing a motion saying he suddenly remembered. Mr. Crawford.
I understand.
Retail fraud, economics, I'm not doing no contest. I mean, they have to be completely obliterated and not be able to provide a factual basis on these cases. I need those, John, real quick, please. The 3 files. Where are the 3 files?
Davis? Oh, I just handed Davis.
Where are they?
I'll just read them. I'm sure.
Here, give me those. People against Kenyatta Davis. Kenyatta Kuru Davis. 25W837-846, 25W838-014, 25W837-845. Defendant failed to appear. She must be at Elmhurst.
Yeah, she's in custody, Your Honor. She's dealing with her pretty bad drug problem.
Did we try to rid her out? Oh,
I'm not sure.
Lisa, I'm sorry, but I'm sending all these files down, including Judge Hesson's 25W838-352, 25W838-232, and 25W837-440. Find out what's going on, Amy. We're gonna have to reschedule those, or if you're sure she had proper notice and was not in custody, send them back to me and I'll put a warrant on in the next couple days. Okay? Sir, we're gonna have you released. Lisa or Amy, make sure that is done, okay? That this gentleman's released on this, okay?
Okay.
Thank you.
Thank you, Russell.
Thank you, Mr. Crawford.
Good afternoon.
You too. Thanks a lot.
Have a physical this afternoon. I thought I'd prepare by having a brisket sandwich and an ice cream cone at the fair. My doctor's not gonna be very impressed when I get there. All right, we are about to take up some jail arraignments. The magistrate is at the magistrate conference. So Judge Pattison and I will be sharing the arraignment duties for the next couple of days. And I knew of these 2 cases this morning, but I was certain that the prosecutor would want to have input on them. So I said we would try to do them at 2 o'clock. Mr. Stickley, the Chief Public Defender, is present with us. And also present is Angelique Camfield from the prosecutor's office, and their victim advocate is also present. Good afternoon, sir. What's your name? All right, Cody Edward McCoy. Mr. McCoy, I'm Judge Vincent. You've been charged with a very serious offense. Let me get to it. Darn it. Sorry about that. You didn't get at it. She can have a seat here. We'll be with her in a minute. As I indicated, this is file number 251883, Cody Edward McCoy. Mr. McCoy, the allegation in this case is from January of 21 to July of 24, sometime during that period. That's a pretty broad period. You did engage in sexual penetration with a child less than 13 years of age. That is a felony punishable by up to life or any term of years. Second count is criminal sexual conduct in the second degree. It's alleged that you did engage in sexual contact with the same child who was less than 13 years of age. And that is a felony punishable by up to 15 years imprisonment. Count 3 is another count of criminal sexual conduct in the second degree. One count of criminal sexual conduct first degree and 2 counts of criminal sexual conduct second degree. Those are very serious charges, punishable by up to life imprisonment. First thing I'm going to do is I'm going to indicate that you're going to plead not guilty to these charges. You have a right to hire a lawyer, but I'm going to make sure that you have one. I'm going to appoint an attorney for you. Set a pre-exam conference for September 30th at 8:30. And if we need a preliminary examination, it would be October 7th at 1 o'clock. Mr. Moore, what's your occupation?
Mr. Moore, Mr. McCoy.
Oh, excuse me. Mr. McCoy, I'm sorry. I was looking at another file. I wanted your. What's your occupation? Do you work someplace?
I'm a welder.
Where's that?
A little fab shop called Ash's Fab. It's just me and the boss.
And where is that?
White Vision. I'm not sure the exact address.
How long have you worked there?
Since May, I believe.
Now, this is alleged to have occurred in Sturgis. Do you still live on Airline Road in Sturgis?
Yes, sir.
All right. Are you on probation or parole?
No, sir.
Have you ever been convicted of anything like this in the past?
No, sir.
They didn't list any supplemental. This is shame on me. I don't have a criminal history in here. I didn't see anything in my system, but I didn't see anything elsewhere. Have you been convicted of anything in any other state?
Just the OWI,
And where was that?
Indiana.
Who do you live with?
Just myself. My grandmother owns the property and the property next door. She lives in the property next door.
All right, as I indicated, Mr. Keith Stickley is here. He'd like to speak with you privately in what's called a breakout room. And I wanted to get some of the particulars out of the way. And I'm going to put you in a private space where you can talk with him, and then we'll talk further.
Okay.
I didn't get any praxis information or anything on this case. And I didn't get a criminal history, and I didn't ask for one, but I didn't see much in our system. All right, Mr. McCoy, one of the things I need to do at this hearing is set a bond. The first charge is what's known as a capital offense. It's punishable by up to life imprisonment. The prosecutor's office is here, and I'm sure they'd like to speak to that issue. Ms. Canfield, what would you like me to know about the prosecutor's input regarding bond?
Thank you, Your Honor. As I'm looking at MCR 2.306, no, I'm sorry. 6105, nope, it's 6106. Parens B 1B. It does indicate the court has the authority with a criminal sexual conduct, first degree armed robbery or kidnapping, if they find proof that the defendant's guilt may be evident or a presumption is great, the court can deny pretrial release under that circumstance. This is one of those difficult cases, however, where it is a young child who disclosed to another child. I'm the one that authorized this particular case, so I'm very familiar with the facts. I did view the interviews of the child after the original disclosure to the sister. The children then went to the mother. The mother then called, as appropriate, the police, took the child for examination, and then subsequently for a forensic interview. There were disclosures not only to the sister, but to the forensic interviewer, that in my training and experience as a prosecutor for over 15 years and a criminal attorney for almost 29 now, that there's a preponderance, at least a very strong one, which is why I authorized it the way that I did. Now, when we look at his criminal history, it is accurate. There is only, to my understanding, no Michigan history and an Indiana history of only an operating while intoxicated, and that was in 2017. When you look at the factors under 6106F, he doesn't have a significant criminal record or one that indicates these types of crimes happening previously. He appears to have resided in the community for a period of time, and his ties to the community would be the fact that he is employed and has a home and apparently his grandmother in the area. My understanding is that the child currently resides out of the state and only came into the state for parenting time, which is allegedly when these offenses occurred, was during the parenting time. So my understanding is that there is no contact between the minor child alleged victim and the defendant at this time, and hasn't been for quite some time since the disclosure. So I can give the court that information. It is a very serious offense, which obviously falls under for F, let's see, F1E, the seriousness of the offense can be considered as along with any threats or whatnot to the victim. Because there is no contact and the minor child resides out of the state, one would think that the risk factor would be less or lesser than if they were residing together at the time. But my concern in instances like this are if he's released, he does have the ability to travel. I'm presuming he has a vehicle to get to and from work. She doesn't live very far out of the state. So that is a concern. She is very young. And it's his own child that's the alleged victim. So that also causes concern of the defendant being on bond release and around any other children. So if there is a bond set at this point and it's not denied under 6106B, I would request that the court put in a no contact provision for the victim, her sister, and the mother of the minor child, that there be a no contact provision with any child under the age of 16 without supervision. And that the court consider a tether, although I know depending upon where he is employed and his financial means, that may be a little bit straining on the defendant, but a tether with GPS that places him in the state and at his place of employment and residence, so that we know if he goes outside of that zone or attempts to leave the state, we'd have a little bit more alert for the safety of the victim if that were to occur. I think there should be no alcohol and illicit substances other than those that are prescribed by a physician while on bond. And that we'll see he and his counsel on September 30th.
All right. Mr. Stickley, you have any input regarding bond?
I do, Your Honor. I would have to stipulate that and agree with the people that this isn't, in fact, an offense that potentially the court rule regarding no bond would be applicable. And I guess I appreciate Mr. Counsel laying out I guess would be a good chunk of my argument that that being said, there are some mitigating factors, I think, to his benefit that would show that there is not necessarily a immediate risk to the community and or his ability not to show up. He doesn't have any sort of criminal record or track record of not appearing in court. I would ask that the court set a bond, the court set an equitable bond, perhaps even a PR bond with electronic monitoring. That might be very appropriate in integration with community corrections. I think that's the reason for community corrections. Any alleged victim, as has already been put on the record, I don't think resides in the state. I don't think that there's been any contact between the two. I'm hesitant to give a full timeline, but my understanding it's been the greater part of a year, maybe more. In terms of him being a flight risk or not participating in court, which is obviously the purpose of bond, is community safety and ensuring showing up to court. My understanding is I think that this gentleman knew that this was sort of kind of out there and did not remove himself from the situation or run. He allowed himself.
I got the impression this investigation had started once before and stalled out and it got resurrected.
So he absolutely promises to show up to court. I don't think that he's run. I think that there's been that opportunity if that was going to be the case. He's asking the court to grant him perhaps even a PR bond with conditions, and no contact is kind of a no-brainer. We'd have no problem with that whatsoever, and enforcement however you'd like.
All right, thank you.
Your Honor, I think what happened with any delay in charging is the fact that this was a very young child initially when it occurred, and it was disclosed to the sister a little bit later. And then because the investigation began out of state, that agency was involved there in Indiana, as well as Child Protective Services in Indiana, that then realized that the actual event occurred in Michigan jurisdiction at the defendant's home during parenting time, which is why it was then shifted to an agency here to complete that investigation and submit for charging. It was at the office and was assigned to me after I became employed here in July. And I did take the time to review the evidence and the videos of interviews before I authorized what I felt were the appropriate offenses.
All right, thank you all for your input.
However, in a case like this, I respectfully disagree with Mr. Stickley. Although we have a victim out of the state, when we have any criminal sexual conduct that's alleged to have occurred, there does appear to be a risk to the community, and particularly the children that are minors.
All right, I'm gonna order some bond conditions and no drugs and no alcohol. No contact with the complainant, NM, her sister, whose name I don't know, or her mother, and you know who those parties are, or any child under 16 years of age without adult supervision. You're not to possess any weapons or firearms and not to engage in any assaultive or threatening behavior. If you are released, you're to be under the supervision of the St. Joseph County Community Corrections by the GPS tether. When I was prosecutor, I handled literally hundreds of criminal sexual conduct cases. That sounds terrible even to say it. I tried 46. I had 2 people today in my court that were child victims when I was prosecutor. From the affidavit, this case seems to rest solely on the shoulders of a 6-year-old girl. I didn't see anything else. I didn't see any forensic evidence like DNA or anything like a recorded phone call or a fingerprint or that sort of thing. There may be a medical evaluation of the child that occurred, but I didn't see it as part of the affidavit. It's entirely her testimony as a very young child about things that happened to her when she was younger still. I'd fall off the cliff of the earth if I were to grant a PR bond in a criminal sexual conduct first degree case. Bond in this matter is $100,000 cash or surety with the conditions as listed. The bond can be revisited if you do not post it at the time of the pre-exam conference or of the prelim. This is a very serious charge, very young child, multiple occasions. That's my ruling. So the bond is $100,000 cash or surety with conditions as stated. If you do post the bond, you need to immediately check in with the Community Corrections Department. That information is on the bond form, and contact your attorney. If you don't post the bond, which is what I expect, your attorney will be coming out to see you at the jail in preparation for that pre-exam conference on September 30th. Mr. McCoy, you're free to go back with the court's jail staff.
Thank you.
All right, thank you.
Good morning, sir. Or good afternoon. Are you Scott Lynn Jones?
Yes, sir.
This is Judge Middleton.
How you doing today, sir?
I'm doing all right. I've got here with me Keith Stickley. He's the Chief Public Defender, and Ms. Angelique Camfield from the prosecutor's office, and the victim advocate is also present. Mr. Jones.
Yes, sir.
I want to tell you what you're charged with.
Okay.
You were charged with aggravated stalking. It's alleged that you did engage in a willful course of conduct involving repeated or continuous harassment of Catherine Ganger, the contact being such that would cause a reasonable person to feel frightened, harassed, intimidated, and threatened. And such conduct would actually cause Catherine Ganger to feel frightened, harassed, intimidated, and threatened. That's a 5-year felony. You're also charged as a 4th habitual offender, which I believe would make this punishable by up to 15 years imprisonment. This was alleged to have occurred here this summer, June 29th and June 30th. How did you come to get arrested?
I went to check into my bank account yesterday, come to find out that all my money was gone off my bank account, and I've been sick for the last year. I've lost 86 pounds.
Well, where
And
were you when you
everything-
got arrested?
I was at home. I pulled up at home and the officers were there.
In Kalamazoo?
In Kalamazoo, yes.
All right.
And as far as June 29th, and I wasn't even around them. I was at home in Kalamazoo, and I don't know how I could stalk them if I'm at home.
Hang on, we'll get to that, sir. We'll get to that.
Well, according to the affidavit of probable cause, I was dispatched to Village of Constantine on June 30th regarding text messages to his ex-wife, Catherine Marie Ganger. Some of this is like deja vu all over again because you had an earlier case with Miss Ganger.
I haven't texted her since.
Hang on, sir, let's not go there. We're not gonna figure this out today.
I can't hear you, sir.
All right, well, don't say anything, but
Okay.
they've got the phones. And,
Because I was served with a PPO order. And
Right.
the guy brought all my stuff back.
Sir, let's not make any more statements, okay? We would ask the court to enter a plea of
All
not
right.
guilty.
Anyway, the messages are very troubling. She said, I have surgery scheduled the next day. Scott said he was going to go to the hospital and stab her if he didn't get the things he wanted. The following are the text messages that I received from Catherine's phone. Since you're not answering, I'll be on my way out. I don't give a fuck if the police are there or not. And then I'm taking all my fucking shit and they're going to have to kill me. I'll see you Tuesday the 1st. It'll be one of the first things you see that will scare you. I'll be waiting for you at the hospital for you tomorrow. You won't even know where I am until you get it stuck in you. Matter of fact, if my shit doesn't get returned, my grill, my lawnmower, my tent, and all my stuff, I will take care of it, but illegally if I have to, but my shit will get back to me. I'll see you in the hospital in the morning if you don't write me back. I'm praying to God that you die tonight before I see you in the morning at the hospital. That's the kind of messages they received off your phone. Now, I dealt with you two as a couple back in 2020. Same sort of thing. Text messages threatening to kill her. That was charged as a felony. I believe it was bound over to circuit court. And you had an earlier case in 2016, and I don't remember if that was Miss Ganger or not. So they're treating this quite seriously. Is the PPO out of Kalamazoo County or St. Joseph County?
Out of St. Joe County. I was served with that. I think in July, actually, they had arrested me for a violation of PPO order on my girlfriend that I had then, and then they dismissed the case because Catherine Ganger called the police, told them I had a warrant for that. And then when I get out, I got hit with a PPO order from her. And I leave her alone. I don't go nowhere near her. I leave her alone. All I wanted was my stuff back.
Stop.
All right,
Sir,
stop,
don't
Jim. Don't say more about it. Well, that ain't how you go about doing it. Stop. Mr. Stickley's right. I'm not mad at you. I just don't want you to say something that could implicate yourself, even acknowledging that you had contact with her. So I'm gonna do the same thing. I'm gonna appoint an attorney and set pre-exam conference for 9/30/25 at 8:30 and a preliminary examination for October 7th.
So is there
If-
a way
yes.
I can get a PR bond or an OR bond? I have doctor's appointments for my stomach. I've been back and forth, like I said, I've been sick since November of last year. Like I said, I've lost 86 pounds. I'm trying to find out what's wrong with me. I was supposed to have an MRI at 10 o'clock last night, Bronson and Battle Creek, and I couldn't make it because I was arrested. They're trying to find out why I'm losing weight and I continuously lose weight. I'm just trying to keep my doctor's appointments in order. I care a lot about Catherine. I didn't mean to say any of that stuff if I said it.
No,
That's what I don't know.
Stop making statements. So, Your Honor, he's asking for a bond to be set fairly and equitably, hopefully with a PR bond.
He ain't getting a PR bond. Stop. We could start at 1 million and work our way up. I'm very concerned about these threats. I had some in 2016. I had some in 2020. I hope you die before I get there in the morning. You're gonna wake up and you're gonna see me before I stick it in you. I'm not sure exactly what that is in reference to. Ms. Camfield, what's the prosecutor's position here?
Your Honor, the prosecutor's position is that under 6106F, the factors and analysis of them would indicate that this man is a danger to not only Ms. Gagner, but to the community. And he has a very violent criminal history. I don't know that he's a flight risk if he's ill and has employment in Kalamazoo. However, there's a 1983 destruction of fire and police property, a 1988 conviction for a traffic offense, an 88 conviction for assault and battery, 94 assault and battery, 96 domestic violence, 97 domestic violence second offense, 99 there was a home invasion and domestic violence that got dismissed. I'm not sure what led to that, but there's a conviction in 2000 for assault with a dangerous weapon for which he was confined in prison. Another conviction in 2000 for drunk driving. 2000, there were malicious phone calls and another assault dismissed in that year in 2001. There's a resisting and obstructing with probation revoked in 2005. Assault and battery in 2007. Domestic violence third offense in 2008 with a 6-month jail confinement. Another 2010 assault with a dangerous weapon and DV third bound over to circuit court. I see a conviction on the assault with a dangerous weapon in 2011. Confinement 2 to 8 years in prison. Malicious calls again in 2010, marijuana 2010, another domestic violence second 2011, strangulation, pled guilty in 2017.
That's here in St. Joseph County. That's
Correct.
26.
And then the aggravated stalking conviction in 2021. Again, in a prison term, and yet here we have again Mr. Jones coming back before the court on another very serious offense with a lengthy history of assaultive crimes. So I do believe he's a danger not only to the alleged victim but to the public, and I would ask that the court set high cash bond.
Mr. Stickley?
I simply ask that bond be set fairly and equitably. I have nothing else.
All right.
Sure. I'm just
Yes,
trying to make it-
Mr. Jones, I'm gonna mute your microphone. I'm sorry about your medical circumstances. This is all on you. This is all on you. Your all baggage has come home and landed on you. I'm in the absurd position that I'm inclined to set this bond higher than a criminal sexual conduct first degree. Bond is $250,000 cash or surety. Mrs. Ganger shouldn't have to live in this fear for this long. Yes,
Is that a bond condition?
yeah.
This is the new. I need to.
I thought I threw those away.
I need to take these from.
Was this the last one? Or is that this
This
one?
is the brand, this is, no.
All right, they were filling them out and
Yeah,
putting them in as
that's,
part
we're
of
trying to
this.
get clarification. I didn't take these out.
All right.
I apologize on that.
No contact with Catherine Ganger. No assaultive behavior. I've never seen this form before.
It's new this week, Your Honor. They're kind of making a transition.
Mr. Jones, I don't expect you're gonna post this bond. The attorney will come out and see you at the jail and discuss this. You may want to share with him your medical appointment schedule, and that could be discussed further at your other hearing. But I'd like to have some input from the prosecutor's office and Ms. Ganger, but this is all on you. Your history came back to roost, and it roosted in the amount of $250,000 with a no contact provision. All right, you're good to go, sir. He's speaking sign language, but I don't want him to say anything else to implicate himself. All right, I have to be there at 3:45. I'm cutting it close.
We will now take up Matthew Schrader on the record now in 2025 TR 1342. State of Kansas versus Matthew Kyle Schrader. Jared Regier for the state. Mr. Schrader, do you appear?
I'm here in pro propria persona, sui juris, appearing specially, not generally, and I reserve all my rights, remedies, and objections.
All right. So I find the defendant does appear personally, and Mr. Regier, his charges and penalties, please.
Your Honor, pursuant to the information filed with the court on June 13th of this year, this is a case that appears to involve two charges. Count 1, failed to register a vehicle and classified non-person misdemeanor. Count 2, no proof of insurance, and class B non-person misdemeanor.
And you said these were allegedly committed when, which date, according to the document?
Your Honor, the charging language in counts 1 and 2 appear to allege occurrence dates on May 21st of this year.
And location within Butler County?
That appears accurate, Your Honor.
Okay. All right, Mr. Schrader, can you still hear me okay?
Yes, I can.
All right, I'm having some issues here, as you can see. In count 1, failure to register a vehicle is an unclassified misdemeanor. It carries its own special penalties of a fine up to $2,500 and a potential sentence of 30 days up to 6 months, although probation is an option and time to pay is an option. And no proof of insurance is a B misdemeanor. That carries a fine of at least $300 up to $1,000 and a possible jail sentence up to 6 months. Now, you do have the right to hire an attorney. If you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed. Because there is the potential for 6 months jail, you would most likely be appointed an attorney if you qualify for court appointed. and cannot afford to pay on your own. On the issue of attorney, do you intend to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
I will waive my right and present myself.
All right, is anyone making you waive your right to an attorney today by any threats or promises
No,
or any other reason?
no.
All right, and you do understand for the record that you do have the right to hire or apply for court appointed if you cannot afford to hire. Do you understand that?
Yes, I'm aware of that.
All right, I will have the record reflect then that you are knowingly and voluntarily waiving your right to an attorney. You're also exercising your right to represent yourself. I'll have the record reflect that in the docket notes and the journal entry. Now then, let's go through these charges. Count one. Fail to register a vehicle. How do you wish to plead to that? You can plead guilty, and that admits it, and we would proceed to sentencing. You could plead not guilty, denying the charge, and we would set it for trial at a later date. Or the third choice, no contest, means you don't want to admit these charges, but you don't want to admit them, but you don't want to go to trial either. So you'd be pleading no contest. We'd still find you guilty without trial and proceed to sentencing today. Another might be, it's not a plea, but another option might be diversion. The county attorney would offer you diversion if you qualified. You'd have to go online, as I've said several times today to others. You'd have to apply and see if you qualify. They'd send you a response within the next couple of weeks in the U.S. mail. If you agreed to the diversion terms, you would sign the contract and send it back. And if you did everything you were agreeing to, they would dismiss the charge or charges against you, charges if they're both diverted. So, but do you want to divert or apply for diversion? I'm not going to say you get it. I don't know your history, and that would come into play. But how do you want to proceed on the issue of diversion or plea?
Okay, so before we get to that, on the record, I've recently served a subpoena to the sheriff's office for records relevant to my defense, and the sheriff's office has filed a motion to quash that subpoena. So today, I'm respectfully asking the court to schedule a motions hearing so that we can resolve the sheriff's office's motion to quash, and that I be allowed the opportunity to pursue negotiations.
All right. You have filed a written motion for subpoena of what documents from the Butler County
Subpoena
Sheriff?
Gus's Tecum.
Of what?
There are many items on there, and
So you don't know what you've asked them to bring to court?
yeah, I do. I don't have it in front of me, but it's a lot of the typical things like body cam, dash camera footage.
All right. And they have filed a motion or a response to quash at least part of what you requested.
Yeah.
Right. And Destiny, do you have both his motion and the response on the file there in front of you?
I show the subpoena, Your Honor, and then I show the sheriff's office motion to quash.
Okay. All right. Well, we will set those for hearing if necessary, but how do you want to plead on these charges before we get to that?
Well, I feel like it wouldn't be appropriate to plea until I get the evidence and I'm able to be informed enough to make an appropriate plea.
All right. So you're telling me you don't want to plead not guilty today. You don't want to plead anything today. Is that what you're saying?
Right.
Well, you understand this is the hearing when that happens. We enter a plea at first appearance. That determines what happens from there. But if you're refusing to enter a plea, and based on what you've told me, I am going to enter a not guilty plea on your behalf, and we can set this for motions hearing prior to a trial date. So how much time, sir, do you think this motion hearing is going to last? Well, I don't know how much time to reserve on my docket.
Are you asking me?
I'm asking you, sir.
How much time I need?
No, I mean, how much time the whole hearing will, you anticipate will be?
20 to 30 minutes.
All right, let's be safe. Mr. Regier, have you seen these documents he's referring to?
I have, Your Honor, and what I would tell the court is it would appear that on or about the same time that the written objection to defendant's subpoena, Dulcis Teacup and motion to quash was filed with the court, an entry of appearance was also filed with the court by Mr. Terrence Hulskamp, the Butler County Counselor.
And Mr. Hulskamp entered on behalf of the sheriff's office, apparently. Did he file the response?
That would appear accurate, Your Honor, based off of the information in this before the state.
All right, so it sounds like he'll be the one that will be responding to that rather than you, perhaps, just to that limited issue, or do you know?
The written response and motion to quash does appear to be filed by Mr. Hulskamp, Your Honor.
All right, let's set a motion hearing on a Wednesday afternoon. Destiny, what do you have available? Somewhere, I would say maybe an hour at the most. And I know that's a lot on the docket because we have so many other things going on, but
And you do want it on an afternoon, Your Honor?
yes, I think so.
We can put it on with the bench trial dockets and still label it as the motion, and we can block off the rest of that day. November.
I'm sorry, I talked over November what?
Nope, you're okay, Your Honor. November 12th at 1:30.
All right, well, that all sounds good. Okay, I'm ordering defendant to reappear for motion hearing on the bench trial docket, November 12th at 1:30. That will be by Zoom. And I trust counsel for the state will, of course, let all of their attorneys know that need to be here. All right, so that's where we are. And then if we decide we need a trial date, I'll set it at that time, Mr. Schrader. Do you understand that?
Yep, sounds good to me.
All right, if there's nothing further, let's see.
Your
You
Honor,
don't- there are multiple matters still to address.
Go ahead, please.
Your Honor, as given the statements made on the record today, the state is requesting a ruling by the court as to whether or not this motions hearing is being set, requested, and this matter is being set over by the defense.
Speedy trial time does count towards the defense if he is asking for this motion hearing to be set and that it be done before trial. And because he did not enter a plea today, I had to enter one for him. So I will definitely count the time against the defendant.
Thank you, Your Honor. Secondly, this is a defendant who seemingly appears pursuant to the summons, so it would appear that the issue of booking as required by statute, specifically pursuant to KSA 21-2501 section B, is outstanding. The state does have certain special recommendations concerning bond in this case. While the state is not opposed to the court ordering an unrecognizance bond, given that the defendant has seemingly appeared pursuant to a summons, the state, in light of statements made on the record, is requesting a higher bond in this case, at the very least $3,000.
Anything you want to say about your bond, Mr. Schrader, before I declare it?
I object to that since I appeared here as I was supposed to.
All right. At this time, bond is set. You said how much, Mr. Regier, based on that?
$3,000 was the state's recommendation, Your Honor.
I will adopt that recommendation. Mr. Schrader, you are ordered to appear at the time given by the officers for booking and processing. Your bond will be set at a 3,000 OR. That means you don't have to put up any money unless you fail to come to court at a later date. But if you fail to come to court, you may be determined to owe $3,000 to the state of Kansas on your bond. So look for the breakout room that says, it'll come up on your screen, invitation to a breakout room, and you'll go in with Deputy in Court Security 2 and set up a date and time. Now, if you fail to follow that order and show up at the date and the time the officer gives you and post the 3,000 OR bond, then I very well may have to issue warrants for you. But Right now, because you did appear when you were told, I'm gonna make it OR, meaning you don't have to put the money up front. You understand that or have any questions about that, Mr. Schrader?
I think I understand it.
Oh, very well. Look
But
for that invitation on the breakout screen. And Destiny, if you'll put that on
can
there
we,
for
can you,
Schrader, for the officer and court security too.
what time? So it's November 12th,
The motions hearing is November 12th at 1:30, correct?
1:30. Okay.
All right. So please accept that breakout room, Deputy. Are you available for that?
I am.
All right, thank you. So Destin, if you'll just put the two of them in a breakout room. Okay, anyone else that you want me to address that I haven't yet, Destiny?
I have no others on my list, Your Honor. Just like I said, it does seem that Mr. Matthew Schrader is still on the hearing with us, so I didn't know if he needed anything else from the court after his hearing.
Let's look at that again. On the record again in VU 2025 TR 434, State of Kansas versus Matthew Kyle Schrader. Jared Regier still for the state. Mr. Schrader still on the docket after being excused.
I didn't hear a recess.
I'm sorry, what?
I just didn't hear that I was given recess.
Okay, I'm sorry you've had to wait this long then, but I am releasing you at this time as you did have your motion hearing set. 11:12 at 1:30.
Yeah.
All right, you may go, sir. Thank you.
Does call the case of the people versus Taylor Meyer.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Mayor. Please the court, Your Honor. Attorney Damien Cash, P number 85852 on behalf of Mr. Taylor Byer, who is approaching the podium, Your Honor. Mr. Byer, state your name for the record.
Your name? Taylor Meyer.
Thank you, sir.
What were you looking on doing with this?
Your Honor, I know he's in person to discuss his recent test results, and at the time I receipt of the second part of the pending plea offer. I'm just asking for a brief adjournment for me and Mr. Byer to further discuss this matter to potentially resolve at the next pre-trial hearing.
Giving this to October 15, 2025, 9 a.m.
Would that be via Zoom, Your Honor?
You have his latest progress report?
I do have his latest progress report, Your Honor.
All right.
And
What did you want to say about it? Because I'm trying to figure out, you want to explain the cocaine?
I've been doing everything.
Mr. Allen. Huh?
I've been doing everything I'm supposed to, and I do not know how that happened. I don't know if there was like a residue or something. I don't know.
You don't know what?
I've done nothing there.
Well, you said, I don't know if there was what?
If there was like something I touched or something, so I know that can be something that can happen, but I've been
Did you get cocaine in your system? That does happen with amoebas. You're saying this got into your system by you touching something?
I don't know. I don't know if it was a false positive or not, but I've been doing everything to not do that. So
You have a medical marijuana card?
yes, Your Honor.
Did you ask for the test to be sent out?
Yeah, I'd like to get it.
Did you ask for it?
Yeah, I
Found
did.
out.
Yes, I did.
Did you pay them for the confirming test?
I didn't pay it yet, but I told them I wanted to get it sent out. My community corrections.
When did you do that?
I just got back here from Traverse City. Like I drove here 4 hours to get here.
Okay, but when did you tell them you wanted the confirming test?
I talked to Maya yesterday about it.
You talked to her yesterday?
Yes, I did.
And then when were you gonna pay for it? What did she say?
She said that's fine and like told me I had to pay $30 and that's what I was gonna go do.
So he wants a hearing on this? Mr. Cash?
Your Honor, I believe we should have, you think between now and the 15th, a hearing, a follow-up hearing on the test results?
Well, I can set a hearing, but I don't know when when the confirmation test is gonna be back, because he's gotta get $30 over there, but he's not gonna be able to walk it over today.
I'll leave it to the discretion of the court, but I agree. I think we should have one hearing between then.
What I'll do is I'm gonna adjourn it out to my next available date at this point, which is October 15, 2025. If you want to motion something up before then you can do it and motion it up. But I'll also set on that date the pretrial and the bond violation hearing. At this time, however, based upon these test results, defendant's bond is revoked, defendant's remanded. Yes, ma'am.
Your Honor, just want to add, just for the record, he is now in outpatient treatment or attending outpatient treatment for substance abuse in Munson Hospital, at Munson Hospital in Traverse City. For the record.
Apparently, that's going well. All right, thank you.
Thank you, Your Honor.
Court calls case, People versus Daquan Mallet. Oh, boy.
Good afternoon, Judge.
You.
The unknown lawyer on behalf of Mr. Mallett.
Your name, sir? Daquan Mallet. Thank you.
Yes. Your Honor, Hugo J. Mack for the official record here. I had the opportunity to speak to Mr. Siller. And
You had the opportunity?
Yes.
Hang on one moment. How'd that go, Siller?
Well, it was kind of over an email, so we didn't really talk.
You didn't really talk?
No,
Okay.
it was efficient. It's efficient.
All right, then we'll call you, we'll just call you Lucky.
Well,
All right.
that's right. It was quite efficient. And Your Honor, I've spoken to my client and he's like to accept responsibility for this conduct and would ask the court to consider height of status.
Well, so I don't know what he wants to do. What do we do?
I believe he's gonna enter a guilty plea, Your Honor, and request height. And of course, I have no objection.
And I have no form.
Okay.
Do you know what form you're looking for?
Yeah, in the milieu of the magnificence here, I overlooked that.
You know, give me a plea form so I can get you out of here.
Okay.
Is this your only case?
Yes, it is.
Good, then you got time.
Okay,
Go ahead,
okay.
sit down and fill out the plea form. You don't do it at my podium.
Okay.
All right?
Excellent.
Client's gotta read all that and sign off on it.
Yeah, we will.
And then we'll, okay. Court calls the case, People versus Min Kim.
Conrad Silver on behalf of Pittsfield Township.
Your Honor, Mark Chiaz on behalf of the defendant, Min Q Kim, who's present in the courtroom. Could you pass on this matter so I have an opportunity to speak to Mr. Siller? Or if you want to proceed, we were here a month ago. I believe Mr. Siller was going to make an offer of impaired, and if so.
That's correct.
But we do not have the paperwork filled out yet.
All right, so
I can fill that out quickly when we do look at the case and come back to it.
I'll pass it.
Thank you, Your Honor.
Court calls the case of the People versus Tracy Purvis.
Conrad Silver on behalf of Pittsfield Township. In this case, we do have.
Yes, I see that.
An
A
assistant,
defense attorney that's prepared. Wow, what a concept. Go ahead.
assistant public defender, for once at least.
No,
Very sorry.
don't
Assistant
under-
public defender Natalie Payworth on behalf of Ms. Purvis, who appears via Zoom. Ms. Purvis, could you please unmute and state your name for the court?
Tracy Purvis.
All right. The plea form indicates that the defendant is going to be pleading to the charge, a count 2 of allowing an eligible driver to operate a motor vehicle, the 90-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes.
That is correct, Your Honor.
All right, ma'am, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, state your name again for the record.
Tracy Purvis.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of allowing an eligible driver to operate a motor vehicle. That's a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Or went through it with your attorney and had her sign it for you?
Yes.
Any questions regarding any of those rights?
No.
You understand that you're giving up all those rights that are contained on that form, including the rights contained under paragraph 5, which are your trial rights.
Yes. I
You
understand.
understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will, and because you believe that you're guilty?
Yes.
May 24, 2025, at the location of State Street, Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes.
All right. Did you allow somebody who was otherwise ineligible to operate that motor vehicle?
No.
Okay.
Ms. Purvis, the judge just asked, did you allow someone, maybe inclusive of yourself, to operate that motor vehicle who was not authorized to do so under the law?
No, I was the only one that was driving that truck when I pushed up.
So, Ms. Purvis, the question he asked you, did you allow someone, maybe even allow yourself, to operate a motor vehicle when you were unauthorized to do so under the law?
Yes. No,
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Ma'am, is there anything you want to say before I impose sentence?
No, only the, October the 3rd is when I get paid.
Okay, so you get a check on the 3rd?
Yes, just Social Security check.
Check, okay. So here's what I'll do. Fines and costs of $250. I'll suspend 90 days in jail. You're gonna, so you've only got, you gotta, let's do it this way. This way you can split it up, okay? So
Okay.
I'm gonna make it payable by December 1st, okay?
Okay, thank you, Your Honor.
You're welcome. All right, take care.
Thank you, Your
Me
Honor.
too.
Thank you, Ms. Purvis.
You're
Court calls case. Court calls the case, People versus Christopher Holt.
Ron Brown, on behalf of Christopher Holt.
Your Honor, we're set this afternoon for a restitution hearing. It's my,
Yeah.
the victim is present, the defendant is not.
Your Honor, we've reached out to him and trying to get him here for this restitution hearing. I just received the documents from probation, and I was going to need time to go over them with him.
Tracy Blair on behalf of probation. Your Honor, Mr. Holt, obviously is already on probation for this case. It was set for a restitution hearing. Mr. Holt was aware that the hearing was scheduled for today.
You informed him of that.
Well, this court did.
Yeah, no, I know,
Yeah,
but
this court did, and it was scheduled, actually at the 9 o'clock block, which everyone is set for. If they're given a time that's later. I am aware that Mr. Holt also has a bench warrant out of the 15th district court. Given that he is not present today, probation asked for a bench warrant.
What was the claimed amount of restitution?
The restitution request is
4456.96.
44.
59.96. Is it 39 or 59?
30.
39 or 59.
30.
39. I'm sorry, Your Honor.
39.96.
And Your Honor, probation had originally requested that that amount be paid jointly and severally with co-defendant Rick Artuso. He was up this morning, 9 o'clock block with David Burgess, and was set for October the 22nd.
Right. Well, what I'm gonna do in this case is the defendant not being here, bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $50,000. I'll give a 10% privilege on that. That warrant will issue immediately.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case People versus James Raggett. Is that it for you, Ms. Feltus?
One more.
One more.
Ron Brown appearing on behalf of James Raggett, Your Honor. Mr. Raggett.
Your name, sir?
James Patrick Raggett.
Thank you.
Your Honor, he's gotten an assessment. We're trying to get our hands on it. It was conducted on on September 12th.
Okay, so we can start, gotcha.
So he's got the assessment done. We're just trying to get our hands on it. So I'm requesting adjournment.
October 15th, 2025, 9 a.m.
Thank you.
Thank you, sir.
Thank you.
Now I can get on my way. Thank you.
I think we're on small.
We're still on small, yes.
Thank you. I know, I got it.
No, we're on small.
Yep.
You got it?
I got it. Simeon Spalding. No. Huh? You know what? Just stop. I got 5 cases left. Stop talking to me. Bench warrant will issue for defendant's failure to appear, bond 5,000, 10%. Will issue immediately. Court does call the case of the People versus Kerry Vickerson.
Ron Brown appearing on behalf of Mr. Vickerson, Your Honor. Mr. Vickerson is a chef. He starts his shift at 2 o'clock and it's 4 o'clock, cuts into his work schedule.
You know what's funny? You said he was a chef and like, he must be hungry. Because I was saying he's just staring at you. Go ahead.
So basically he had a work schedule conflict. So I was asking for an earlier time in the day in an adjournment.
But
So-
you've been in contact with him
Yes.
and he just needed a different time, but weren't able to accomplish that.
Yes, Your Honor.
I'll adjourn it, October 15th, 2025, 9 a.m.
Thank you.
Court calls case People versus Wesley Boss.
Conrad Silver on behalf of Pittsfield Township.
This is how the defendant Natalie paid for Mr. Ross, who had authorization to accept the offer on his behalf.
Got it.
Your Honor, move that counsel double parking. If you accept the admission, dismiss free from charge.
And Ms. Pate, on behalf of your client, do you admit responsibility to the fact that he double parked a motor vehicle on July 3rd, 2025 on Michigan Avenue in Pittsfield Township, Washington County?
Yes, Your Honor.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. I'm gonna ask when your client get paid. If you tell me Halloween, I'm coming off the bench.
What's a Halloween? Ad for 30 days.
I'll take that. October 17th.
Thank you.
2025. Court does call the case of the People versus Trevion Weaver.
Conrad Silver on behalf of Pittsfield Township.
By the clerk.
Sorry.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $2,500, 10%. That warrant will issue immediately. Court does call the case of the People versus Nathaniel Wiles.
Conrad Silver on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Mr. Wells, Your Honor.
Bet you he wishes his name was Adams. But go ahead.
I shared a valid license with Mr. Siller,
That's correct, Your Honor. So I can get count 2 of double parking.
and he'll,
Gonna admit double parking and do allow that mission to dismiss.
Answer. Do you admit responsibility to the fact that they can type it in there, right? That on the date of September 2nd, 2021, at the location of West Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, that you double parked a motor vehicle.
sir,
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can you get that paid, sir?
A month or two. It's only $180.
Pardon?
It's only $180.
It's only $180. So you got it now?
No, sir, I do not.
Okay. Thought I'd
A
ask.
whole lot cooler.
Well, the way you said it, I thought I'll ask. Maybe he's got it tucked in his sock or something. All right. I'll give you to October 31st. Will that work for you?
Yes, sir.
You just didn't want to ask for that date. He's
No, I
been
didn't.
watching. What? I'm gonna be busy on Halloween finding people that haven't paid. All right.
Thank you.
Take care. Take care, sir. This is what we call, and I got that's
Collinson.
oh. Well, hold on, but Mac, what are you doing? Wait. Talk to the man, and let me do this one, Bob. You're doing. He's just been loitering up there. I didn't know what he was doing. Court recalls the case, People versus Min Kim. Somehow that paperwork got here, but.
Good afternoon, Your Honor. Marquez on behalf of Min-Gyu Kim.
Sir, your name?
Min-Gyu Kim.
All right. And the plea form that I have indicates that he's going to plead to the charge of operating while visibly impaired. The 93-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
That is correct, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Min-Gyu Kim.
Sir, it is his court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes.
Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
You have any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium there. Those are your rights, which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're indeed guilty of this offense?
Yes, Your Honor.
On the date of May 4th, 2025, at the location of Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consumed intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had whiskey, Your Honor, and probably around 4 drinks of whiskey.
Okay. Were you stopped by the police or was there an accident?
I was not
There was no accident on here. I was just stopped by the police.
All right. Why'd they stop you?
Um, I turned and I missed a corner, Your Honor.
Okay. You're not disputing the right of the police to stop you in this case, are you?
I am not, Your Honor.
Okay. Were you ultimately arrested?
Yes, Your Honor.
All right. Were you taken to the hospital or to the police station?
I was taken to the hospital first for a blood draw.
Blood draw. All right. And what were the results of that blood test?
It was 1.8 or part 1.
0.181?
Yes.
All right. Do you have any reason to dispute those test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rule between today's date and the time of sentencing, that you would not be entitled, the court would not be bound by any evaluation on your case in regard to your sentencing, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
October 22nd at 12 p.m.
October 22nd, 2025, 12 noon. Will that work for you, Counsel?
I'm checking
No,
as
wait.
quick as I can.
I love when somebody's got a paper calendar.
I was gonna mention that fact, Your Honor, but you're very observant. October 22nd at noon is fine.
All right. Yeah, I'll set it for that time. Bond with its conditions will continue. Thank you, sir.
Thank you, Your Honor.
Court does call the case. Recalls the case of the people versus Daquan Mallet.
Conrad Sullivan, yeah, Pittsfield Township.
Go, Jim. Mac, long time no see, Judge.
Yeah.
Your Honor, we do believe we've proffered the proper paperwork to the court.
Yes, it is finally here.
Yes, and so we would
All right.
stand and accept responsibility, Your Honor, for this
All
matter.
right. Well, he's going to plead guilty to the charge of trespass. And this form indicates that he's going to do that. Prosecutor will recommend HIDA in this case. Although it's not necessarily binding the court. Understand?
Yes, Your Honor.
That's the court's understanding.
That is correct.
May I have the defendant's word?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help me God?
I do.
State your name.
Daquan Mallet.
All right. Sir, it is this court's understanding that you are going to plead guilty to the charge of trespass. Misdemeanor, punishable by up to 30 days and a $250 fine.
Yes, sir.
All right. Plus court costs. You understand that? Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any?
Yes, sir.
All right. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights? Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense? On the date of July 25th, 2025, at the location of 3825 Carpenter Road in Pittsfield Township, that big Meyer, the Meyer store. Were you on the premises of Meyer?
Yes, sir.
Had you previously been told to leave and or were you told to leave on that date and refused to do so? Which one was it?
Previously told to leave.
You had been previously told to leave?
Yes, sir.
And then you came back to the premises at some point after being told to leave and not be on the premises?
Yes, sir.
All right. Sir, if I accept your plea and you commit misconduct between today's date and the time of sentencing, misconduct is defined by the Michigan court rules. The court would no longer be bound by any sentencing recommendation to the court, and you could not withdraw your plea. You understand that, sir?
Yes, sir.
All right. And counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty.
We thank the court for kindly considering height in this matter of court's discretion.
Good. So what I will do is I'll refer the defendant to probation. For a pre-sentence investigation and report and consideration of the HIDA status. Sentencing in this matter will be October 22nd, 2025, 12 noon.
Yes, Your Honor.
Bond with its conditions will continue. All right. Thank you, Mr. Miles.
Okay, thank you, Judge.
Thank you.
Thank you.
Court calls the case of the People versus Michael Collis.
Ashley Feltus for the people.
Ron Brown appearing on behalf of Mr. Collison, Your Honor. Please state your name for the judge. Yes, Your Honor, Michael Scott Collins. Your Honor, we're here for a bond violation sentencing. I provided documentation from Oakdale Recovery to the prosecutor and to the court. I believe he is welcome back to Oakdale.
Say again.
I believe he's welcome back to Oakdale Recovery. I've provided information to the court and the prosecutor.
So he can be released to treatment?
If the court says so.
Spouses, anything?
Your Honor, I think the court recalls, but just in case the record needs to be sort of fleshed out a bit more. The defendant had been released to go to Oakdale.
Correct.
When in Oakdale, there was a tamper violation with a cut strap. I understand there may have been a dental appointment in this mix that ran over or something to that effect, but certainly cutting off the tether is not the reaction we would like to see. If the court ultimately rules the defendant can be released to inpatient treatment, I still want a GPS tether, frankly. I think that that's important, but I would hope that the court, for lack of a better term, would sort of impress upon the defendant how incredibly important it is to remain compliant with this bond. My office gave him a considerable offer in this case to plead guilty to an added count of use as opposed to the possession of methamphetamine or ecstasy, which is a 10-year felony, into the 1-year misdemeanor. So I'm just concerned that the reaction is to cut off the tether, and I don't want to see it happen again.
So how long has he been in thus far?
Looks like since the end of July, if I'm reading this all correctly.
And substantial time before then.
Whoa, but he's been in about 45 days on this violation.
Correct.
So what would make me think that releasing him back on the tether is going to work this time?
I think
We got a crazy story about, were you at the dentist?
I was. There was a mix up with the timeline.
So why'd you cut the tether?
I was trying to get back into treatment.
I understand.
I was only like 8 days away from completing. And I've been homeless for 4 years, and I had a move-in date on August 6th, and I begged them to let me back into the treatment center. They said no because of the time, and I was just afraid of losing everything I built, and I panicked, and I made a really bad mistake, and I promise I will complete the treatment. I've had a lot of time to think of that, like that mistake. You know, I've been in jail for 45 days rerunning that day. And I have so much regret about it. I just want a second chance. I beg if you would let this 45 days or whatever it be dead time. And you know, I understand if I mess up, I have a whole year I have to serve.
How long is
28 days. Plus
the
detox.
aftercare.
I need detox too.
right? Okay, here's what I'm gonna do. I'm gonna do it this way. I'll sign an order releasing the defendant to treatment at Oakdale. I will adjourn his sentencing on the bond violation. You need to complete that program and be in the aftercare portion of things.
Okay.
Otherwise, you're gonna just sit. I'll give you a second shot.
Okay.
All right? But we'll sign a new tether order. He'll be released to treatment, but he won't be released prior to placement on the GPS tether. And I'll adjourn his sentencing. If it's a 20-day program, you probably have some detail. You're right in there. I'll adjourn his sentencing November 5th, 2025 at 9. If it looks like he's not completely through at a good point, then let the court know. We'll figure out a date.
Understood. Thank you, Your Honor.
Thank you. You might want to make sure to prepare a fresh order. I'll prepare the community corrections order.
Yes, Your Honor.
You're gonna get my community corrections order. You don't even know what I said. Well, it doesn't matter. It's in a day. I'm entitled. 14A. Stands adjourned. Thank you, Alan. Thank you, Anna. Thank you. What's your name? Anna.